Hey everyone, it's Rob Ryder, 29th of January 2012. My details, as you can see, some great things have been happening, pushed forward by good people simply asking questions of their elected officers. These officers have a fiduciary duty to you, the king. When you accept their oath, bind them to it, remind them they have a fiduciary duty to you as one of God's people. Oaths are written as common law deeds, and as a grantee, you have to acknowledge and accept it for it to be binding between them and you. Then, give them a lawful order. Let them know if they do not follow your lawful order, you will have them before the court of inquiry. And in Michigan, that's part of the probate court, so they say. More on that later. The question is, what questions to ask after accepting those of these officers? Well, for that I'm relying on Lord Coke and Lord Blackstone, books of authority. Used as evidence in your case is the law. They tell you how the system is set up and where to find the remedy. They will tell you how to succeed in every suit if you go as a sovereign, one of the king of kings, kings, or queens. Turns out, from my interpretation, it's just misdirection being used because, as Lord Coke says, point out their error first to see their last. Something along those lines in Book 4 of his book, under the court of request. So this can be a series of videos. Use my study notes meant to show the overall picture, not the exact answer. That will come from asking questions of those who know the answer. It will take as many videos as it takes. First in outline, later in details as we learn more by doing. Asking questions of our public record. On our public records are acknowledged and attested free will, act, and deed, or man to man. So you can put your questions on a document. Just make sure you do it as a public record. And we'll talk more about that later. But you've already been doing it on those who have done warranty deeds and so forth. You know what I'm talking about. So I'm going to be skipping between Lord Coke and Blackstone, and I'm going to include this, what I'm reading to you now, along with the video, and it will be posted. Go back to that real quick. It'll end up here at robcorderrecord.wordpress.com, and I'm going to ask Cynthia to set up a special file just for this information, along with the videos. It'll all be in one place, and that way if you refer somebody else to it, they'll be able to find it. So when I do that, then here's the books I'm using. Right, this is an online version of Blackstone. These are downloadable books off of Wikipedia. The main one I'm using is the number 8. You'll see it at the bottom. It's the fourth book, the 1797 edition. That's for Lord Coke. An online version of Bouvier's 1856 Law Dictionary, and an online version of Webster's. So, if you're directed to this video and are unfamiliar with the subject matter, don't be discouraged if you don't get it right away. You've been conditioned to look the other way and to think certain words mean a particular thing. If you don't think any of this matters or will not be acknowledged by them, then don't worry about it. Again, it's only my interpretation of some old dusty law books. So you don't have to agree. Everyone has free will. I've chosen to exercise mine in a particular manner and down my own path. And I'm trying to find the Achilles heel of civil law. Because even a wooden boy, Pinocchio, knows that every contract has an escape clause. So let's see what we can find out from these old books. So first of all, in Lord Coke's Institutus of Laws, this would be in actually his second book. So from that list above, you can find book 2, this page 47 of the PDF, where he's breaking down the Magna Carta. Now, everyone has their own interpretation of what that means. I'm going to take his because they say his book is an authoritative book on law. I'm not going to argue. So we're going to learn some names we probably heard before for courts, but what do they actually do? So this is what is in Chapter 11 of Magna Carta. Common pleas shall not follow our court, but shall be holden in some place certain. And so when he says not follow our court, he's talking about the King's Bench. Before the statute, common pleas might have been holden to the King's Bench, and all original writs returnable into the same bench. So writs would be returnable to the King's Bench. And because it was holden before the King and followed the King's court and removable at the King's will, the returns were, wherever we have been, whereupon many discontinuance ensued, and great trouble for jurors, changes of parties, delays of justice. For these causes, the statutes was made. So that's what they say, right? Basically, the king could say, well, I don't agree with that, and change the outcome. And so many discontinuances would be like a discharge. So here it is understood, a division of the pleas. For the pleas are divided into pleas of the crown and common pleas. Pleas of the crown are otherwise and aptly called criminal and mortal. Well, golly, look at that. So pleas of the crown are criminal or mortal. And looking down, mortal, man is mortal. So if a man has a issue, he goes to the king's bench because he has a plea of a crown. Pleas of the crown. You are the crown. So the other one is called civil. The king's bench is divided into high treason, misprision of treason, petite treason, felony, and to their accessories, so called, because they are against the dignity of the crown, and for these the court of common pleas cannot hold plea, because they be held by common persons. So, at the end of the day, the court of common pleas is all civil law, and they cannot hold anything to do with the king's bench. So, for a plea of the crown may be held between common persons as appeal for murder, robbery, rape, felony, may be a part of the common plea. So basically, what they're telling you here, and we'll get into this more, is you can appeal anything from a civil court into the king's bench. We have not done that. It's not the appeal court they tell you to do. It's part of the king's bench. We need to identify the king's bench. One of the other things the king's bench has is a court of inquiry, and a gentleman here in Michigan emailed the probate register and asked her, is the probate court the court of inquiry? He got a one-word answer back, yes. So now, as are of the old fields must come new corn, so old books do excellently expound and express this matter, as law is holden the day. Therefore Glanvin says, it is one thing for criminal pleas and another for civil. So there's two different things. One is criminal pleas, that's also mortal, that's for man, and then there's civil, which is for citizens. So the criminal plea is a right in the crown, and the other one is a right in the civil, right in the common. And then it also has the king, his court, his justices, who sat down before them, the record of which I shall have in these, I can't remember what placidia, I guess places, and who have the power of all pleas and actions, personal and real. So the king's bench has jurisdiction over everything. It has concurrent jurisdiction in every civil matter whatsoever, every matter of equity whatsoever, because equity follows the law. If it's not lawful, it can't be equitable. So if a man be held in custodial marishi of the king's bench, any other have an action of debt, conveyance, so forth, by bill in the king's bench, because he is in custodial. So if you're in this custodial position, you ought to have privilege of the court. And the act taketh not away the privilege of any court. Man can answer in what court he desires, because he should be sued in any court, and he should not, in respect of his privilege, answer there. And so it is, any officer, minister of the court, the like, law in this court of chancery and esquire. Now this custodial mareshalli, when we look in Book 4, Court of Exchequer, they have an officer that's very similar to mareshalli, just sort of different. And he's your custodian. He's the officer who has custody of your estate, or one of them. So, Book 4, Chapter 8, Court of Chancery, page 110 of the PDF. So now we're going to talk about the Court of Chancery. The one before was the Court of Common Pleas. Chancery is the only court of which original writs issue. Remedial. Remedial, that which affords a remedy. A remedial statute. The term remedial statute also used applies to acts which give a new remedy. So you could write your own remedial statute. If you took it to the chancellor and got him to put a seal on it, it would be the law. Statute also sometimes means a kind of a bond, an obligation of record. And so that's statute merchant, statute staple, which are the bonds that are running in the court that's running in the back of the court that you're in. They take you into a civil statutory court, and at the same time they're running in the background through equity, another court, and they're gambling. They can get you to sign these bonds and acknowledge that you owe the debt. That's what they're doing. It's just gambling. Let me see. I think I want to pop this down here. I have it right for next time. So page 112, jurisdiction of the court. Chancery has two courts. One ordinary, where the Lord Chancellor or Lord Keeper of the Great Seal proceeds according to right in line to the laws and statutes of the realm. Another extraordinary, according to the rule of equity. So the Court of Chancery has two courts going at the same time. One in equity and one under statute. Upon judgment given in this court, a writ of error does lie returnable to the King's bench. So again, anything that comes out of Chancery or comes out of the Court of Common Pleas is returnable, a writ of error, to the King's bench. You always have the right to appeal to the King's bench. So this court is works of righteous out of the original writs, and all commissions which pass under the Great Seal go forth, which the Great Seal is the keys of the kingdom. And for those ends, this court is ever open. So what we're going to find out later as we go through this, anytime somebody brings a civil action against you, one of the things that they could do is they could go to the chancellor and get a writ under the seal of the chancery. In England, for instance, in London, it's the Archbishop of Canterbury. He's the chancellor. Rob, the guy I did a conversation with the other day, who had talked to his to a clerk of the court, of the county court. He told me it was a clerk of the county court out in New Mexico. One of the answers he got or was told from this clerk was that he should go see the archbishop in the town next door. That archbishop is the chancellor for that diocese or whatever they call it. And they're the keeper of the Great Seal. So one of the things you could ask for in any civil case, I demand to see the original writ under the Great Seal of the Chancery. We'll find out how to exploit that later. If it isn't there, then one of their two options is gone. Everything has options, right? Well, if that isn't there, then they can't use anything else that has to do with that. That's pointing out the error in the beginning. I don't care what the paperwork says. Do you have it under the seal of the chancellor? If not, that eliminates half the things they can do. Now they have another half to deal with. So the officers and ministers of this court of common law do principally attend and do their service to the Great Seal as the 12 masters of chancery. Now the interesting thing is, it's the keys out of which all original writs and all commissions which pass under the Great Seal go forth, which the Great Seal is keys of the kingdom. And we're going to find that to get out of this system, whether we do it or it's done for us, will be an original writ out of chancery that will start a common recovery for you to claim your inheritance and your status as alive as one of the King of Kings kings. Now they also have extraordinary jurisdiction. So the top was just ordinary. Now this is extraordinary. This is the equity side. And in there it says, there is no statute that gives a party grieved remedy in equity. You cannot argue a freaking statute. He's telling you that this is a book of authority brought into court, used as your evidence, is the law. There is no statute that gives any party grieved remedy in equity. Meaning the makers of the act to direct the party to be relieved by the common law, by actions upon these states and not elsewhere. You have to go to common law to get a frickin' remedy. He's telling you. Cannot make any order against the common law, nor any judgment to be given without due process of law. No person should appear upon a writ certain about the cause of some before the chancellor or any other of the council, where the recovery is therefore given by the common law. So if the dude had a recovery by common law, he should have taken you there. He shouldn't be bringing you uh, into the court of chancery. No person should appear upon a writ certain about the causes of some. If they're certain, it shouldn't go before the chancellor or any other of the council. One recovery is therefore given by the common law. As people was compelled to come before the king's council in the chancery by writs grounded upon untrue suggestions, that the chancellor, for the time being, presented after that such suggestions that duly found and proved untrue, shall have the power to ordain and award damages according to his discretion to him which has travelled unduly and as foresaid. So when you point these things out, you're going to get the penalty. The other guy's in trouble. The attorney who brought the charge is going to have himself a bad day. This act extendeth to the chancellor proceeding in course of equity, and extendeth not to demur in the law upon a bill. So if they're using a bill, then this doesn't apply. If they're going in equity, then it does. So they're talking about a demur in loss. That would be in common law. That wouldn't be in equity. I had to look up demur again to see exactly what that is, but no problem. Again, I'm just going through it as I go and trying to make it all fit together. No man may be called by privy seal or subpoena to answer any matters that have such a remedy by the common law. So again, if you're going into a civil court and you look at the paperwork and it has a privy seal, which is under the court of record, the private seal of the court, no man should be called, but such have a remedy by the common law, and that to appear to by the testimony of two justices of either bench, and the indenture between them and the plaintiff, which plaintiff shall always appear in proper person. It means the plaintiff has to be there. Can't send an attorney. He can be represented by one, but he better be there with him. And find surety by recognizance to prosecute which affects the matter of the bill only, and answer damages and all the same fallout, and to answer damages in the same fallout against the plaintiff. So again, no man to be called by privy seal or subpoena to answer any matters but such as have a remedy by the common law. So if they have you in there under a privy seal, which is seal of court, there is a remedy in the common law, and we need to take it to common law because they've entered this into a case that they're doing in the chancery. The court of equity proceeding by English bill is no court of record, and therefore it can bind but the person only. How'd this get all messed up? Okay, sorry about that. So the court of equity proceeding by English bill, which is a procedure that will be explained more fully as we go through this, is not a court of record, and therefore it can bind only the person. So that's just a brief introduction to a couple of courts, and you know, I've really just cut and pasted parts out of what I've read. You go back and read it for yourself, the rest of what it says in those chapters. But based on that, I want to go into my buddy William Blackstone, and we're going to look at Book 3, Chapter 17, of injuries proceeding from or affecting the crown. So, you know, we're going to find out who's who in the zoo. And then basically from Chapter 17 down in Book 3 is explaining all the things that happen in court. And so my plan is to go through each one of them and kind of do what you see now, picking out the things that speak to me, looking for certain definitions, and then trying to explain them. And if I'm incorrect, I don't mind being corrected. Please let me know. But if it says what it says and you say that isn't how it is, then, you know, don't blame me. Blame them. They're the ones who wrote the book. Having the 9 preceding chapters, consider the injuries of private wrongs that may be offered by the command and authority of the king, signified by his original writs, returnable in his several courts of justice, which thence derive jurisdiction of examining and determining the complaint. I proceed now to inquire the mode of redressing the injuries which the Crown itself is a party. Which injuries are either where the Crown is the aggressor, which therefore cannot, without solipsism, admit of the same kind of remedy, or else is the sufferer, in which there are only remedial by particular forms of process appropriate to the royal prerogative. In treating, therefore, of these, we will consider first the manner of redressing those wrongs or injuries which may suffer from the Crown, and then redressing those in which the Crown may receive from the subject. First of all, that the king can do no wrong. That's really good to know. That's why you want to be the king. Is a necessary and fundamental principle of the English Constitution, meaning only, as has formerly been observed, that in first place, whatever may be amiss in the conduct of public affairs is not chargeable personally on the king, nor is he, but his ministers accountable for it to the people. So if there's a problem, they made the mistake, go tell them. The king's not responsible for anything. He's not legally liable for anything. And secondly, that the prerogative of the Crown extends not to do any injury, for being created for the benefit of the people, it cannot be exerted to their prejudice. Where therefore it happens that by misfortune or misadventure the Crown has been induced to evade the private rights of the subject, though no action will lie against the sovereign, who shall command the king. Yet the law has furnished the subject with decent and respectful mode of removing that invasion. I wonder if they're trying to use that against us, by informing the king of the true state of the matter in dispute, and, as it presumes to know of an injury and to redress it are inseparable in the royal breast, it then issues, as of course, in the king's own name, his orders to his judges to do justice to the party aggrieved. So they're going to get you to sign your name and admit that you did something wrong, because you're the king. They're going to get it under your seal. The distance between the sovereign and his subjects is such that it rarely can happen that any personal injury can be immediately and directly proceeded from the prince to any private man. Now, look at, they said private man. Man is the superior word. Anytime you start to modify a word with another word, you've made it inferior. A private man is not the same as a man. It's inferior. So they're basically saying to a subject, a prince to any subject. And as it can also seldom happen, the law in decency supposes that will never or can happen at all. But it feels itself capable of furnishing any adequate remedy without infringing the dignity and destroying the sovereignty of the royal person, by setting up some superior power with authority to call him to account. So they're going to set up a way to call you into account. The inconvenience, therefore, the mischief that is barely possible, well, recomps by the peace of the public and security of the government in the person of the chief magistrate being set out of reach of coercion. The chief magistrate's our man. He's been set up out of reach of coercion. I don't know how many of you ever watched Return to Oz, but he's TikTok. But injuries to the rights of property can scarcely be committed by the Crown without intervention of its officers, for who the law in matters of right entertains no respect or delicacy, but furnishes various methods of detecting the errors of or misconduct of those agents by whom the king has been deceived and induced to a temporary injustice. So, if it appears that something's been done wrong by the king, it's not his fault. It's his officers' fault. They're supposed to handle that stuff. So that's when you take him to the court of inquiry. WTF, what are you doing? The common law method of obtaining possession or restitution from the Crown of either real or personal property are by a petition of right, which is said to owe its originals to King Edward I, and then also by manifestation or plea of right, both of which may be preferred or prosecuted either in chancery or exchequer. So there's two ways for the common private man to bring an action against the king. One of them is a petition of right, and the other one is a plea of right. So the former, the petition of right, is used where the king is in full possession of the hereditaments, chattels. Party suggests such a right as controvert or to dispute the title of the crown, ground of the facts disclosed in the petition itself, which in case he must be careful to state fully the whole title of the crown. Otherwise the petition shall abate, and then upon this answer being endorsed or underwritten by the king, let the right be done to the party. A commission shall be issued to inquire of the truth of the suggestion, after the return of which the king's attorney is at liberty to plead and bar, and the merits shall be determined upon issue of demurrer, as the suits between subject and subject. There's that word demurrer again, so that's fitting into something they said earlier. And again, I don't have all this stuff in my head yet, but I'm just trying to take the pieces that are said before and put them into where they go later. Possession of the hereditaments, which is anything capable of being inherited, be it corporeal and incorporeal, real, personal, or mixed. So, if you're in full possession of those, right, then this is what they would use. They would use the petition Detroit, a petition of right, which is said owed in its origin to the king Edward I. And it's to dispute the title, but it has to say in there, be careful to state the whole title of the crown. So if there's a case in, one of the things to look for is this petition Detroit. It looks like Detroit. Thus, if a decider, one who puts another out of possession of his lands wrongfully, go figure, of lands which is held of the crown, dies seized, having possession, without any error, whereby the king is on its face entitled to the lands, and the possession is cast on him either by inquest of office or by act of law without any office found. Now the one who is wrongfully put out of the possession of his lands shall have remedy by petition of right, suggesting the title of the crown and his superior right before the decission was made. Okay, so if some dude is wrongfully taken your stuff and then he dies, they would do an inquest back in the day to see whose the property it was. And if he had no error, without an error, whereby the king on his face is entitled to lands and possession is cast on him. So then possession went back to the king. Shall have remedy by petition of right. So that's when they would use the petition of right, because the other one wasn't a petition of right. What did they call that? They call it a plea of right. It's different than a petition of right. Okay. But where the right of the party as well as the right of the crown appears upon the record, and the party shall have a showing of the law, which is putting in a claim of right, grounded in the facts already acknowledged and established, and praying the subject the judgment of the court, whether upon those facts the king or subject has a right, as if the case being supposed, the whole special matter is found in quest of office. And a party grieved shall have this monstrous Detroit at the common law. But it seldom happens, and the remedy by petition was extremely tedious and expensive. The other one was much larger, rendered almost universal by the statutes. So they're saying that they're mainly using this one here, showing of the law, which is putting a claim of right grounded on facts already acknowledged and established. And when you read about statutes, staples, statutes, merchants, they're saying that's a security that you have acknowledged. Well, before they could bring that to court, you would have had to acknowledge it. Right? But that's not the one that's being tried in the front room. That's in the back, and they're gambling. They're going to get you to sign those bonds and acknowledge the debt. So these proceedings are held in the petty bag office in the court of chancery. And if upon either of them right be determined against the crown, the judgment is the king's hand removed, the possession restored to the petitioner, saving the king's right, which last clause is always added to the judgments against the king, to whom no laches is ever imputed, and whose rights are never defeated by any limitation or length of time. So it doesn't matter what you did before. When we find out what it was, we can go back and undo it. You can appeal everything that's in a civil court to the king's bench. And by such judgment, the crown is instantly out of possession, so that there needs not the indecent interposition of his own officers to transfer the seisin from the king to the party agreed. So they don't need to do anything. You're going to do it yourself. The methods of redressing such injuries as the crown may receive from the subject are. So that's what they can do, the subject can do to the king, and this is what the king can do to the subject. They're down to one thing, basically, from this, that they're mainly doing this showing of the law, which is putting in a claim of right grounded on facts already acknowledged and established. For that to be, you have to already have acknowledged these bonds. So, by such usual common law actions as are consistent in the royal prerogative and dignity, as therefore the king by reason of his legal ambiguity cannot be decised or disposed of any real property which is once vested in him. He can maintain no action which supposes a dispossession of the plaintiff, such as an assize or an ejectment, but may bring a quare why impeded. So he can bring a writ of why impeded, which always supposes the complainant to be seized or possessed of an advowson. I wanted to get that. That's an ecclesiastic term, sort of like a benefice, or a charity, or a gift. And he may prosecute this writ as well as every other, in the king's bench as the common pleas, or in whatever court he pleases. So too he may bring an action of trespass for taking away his goods, but not for breaking his close, or any other injury upon his soil or possession. It would be equally tedious and difficult to run through every minute distinction that might be gleaned from our ancient books with regard to this matter, nor is it in any degree necessary. A much easier and more effectual remedies are usually obtained by such prerogative modes of process as are peculiarly confined to the crown. Such is that of inquisition or inquest of office, which is an inquiry made by the king's officer, his sheriff, coroner, excheater, by virtue of office, or by writ to them sent for the purpose, or by commissioners specially appointed concerning any matter that entitles the king to possession of lands, of testaments, goods, and chattels. This is done by a jury of no determined number, being either 12 or less or more, as to inquire whether the king's tenant for life died seized, whereby the reversion occurs to the king. Whether A, who held immediately of the crown, died without heirs, in which case the lands belong to the king by his cheat. Whether B, be attainted of treason, whereby his estate is forfeited to the crown. Whether C, who has purchased lands, be an alien, which is another cause of forfeiture. Whether D, be an idiot or nativity from birth, and therefore together with his lands appertains to the custody of the king, and other questions of like import concerning both the circumstances of the tenant and value of the identity of the lands. These inquests of office were most frequently in practice than... Oh, hang on a second here. These inquests of office were more frequently in practice than at present, so they were used more before than they are now. During the continuance of the military tenures against us, we're still under military law, we're under martial law. Whether upon death of every one of the king's tenants, an inquest of office was held by the inquest after death, that's coroner's inquisition, to inquire of what lands he died seized, who was his heir, and at what age, in order to entitle the king to his marriage, wardship, relief, primer seisin, and other advantages, as circumstances of the case might turn out. To superintend and regulate these inquiries, a court of wards and liveries was instituted. The Court of Ward and Liveries. That'll be another interesting book. which was abolished by the restoration of King Charles II, together with oppressive tenures upon which it was founded. Yeah, right, that we're still under him. With regards to matters, the inquest of office still remains in force, and are taken upon proper occasion, being extended not only to lands but also to goods and to chattels personal, as in the case of wreck, treasure trove, and the like, especially as to forfeitures for offenses. For every jury which tries a man for treason, felony, every coroner's inquest that sits upon a suicide or one killed by accident is not only with regard to chattels, but also to real interest, in all respects an inquest of office. And if they find the treason or felony, or even the flight of the party accused, though innocent, the king is thereupon, by virtue of this office, found entitled to have his forfeitures. And also, in some cases of accident, he or the grantees are entitled to such things by way of, I don't know what that is, as have moved to the death of the party. So, the king can use the court of inquest, it sounds like, as one of the remedies. Now again, need to think about that more and see what that means. I don't know that that's the easiest one. Let's see if he's got something easier. These inquests of office were devised by law as an authentic means to give the king his right by solemn matter of record. So we need to have an inquest on us before a jury so that we can have our stuff. Basically, live as a man, not under civil law, a man who's a law unto himself, following two basic laws: honor the father, heart, mind, and soul, treat your brother like you treat yourself, without which he in general can neither take nor part from anything. For this is part of the liberties of England, and greatly for the safety of the subject, that the king may not enter upon or seize any man's possession upon bare surmise without the intervention of a jury. So I contend that they control our landed estate and our property and our body. We're a party to a deed. We were made a grantor on a deed as an infant, but all infants' deeds are avoidable. Yet this. So where's the record? Well, here's the record. That's the, in my case, the certified copy of record of birth that shows that it's mine. Right? Where's his copy that shows that it's his? So it is, however, particularly enacted in some statutes that in case of attainder of high treason, the king shall have forfeiture instantly without any inquisition of the matter before office found. The finding of an office found means the finding of an inquest of office. Therefore, by some more statutes, was enacted that all letter, patent, grants, and lands, tenements before office found or returned into exchequer shall be found. So when they find your office, then anything that's been done before that shall be void. They just had to find your office. That's what the inquest says. The finding of an inquest of office. Are you the king or not? It is declared that all grants and promises of the fines and forfeitures of particular persons before conviction, which is here the inquest of office, are illegal and void. So all grants and promises of fines and forfeitures of particular persons before conviction, which is here the inquest of office, are illegal and void, which indeed was the law of the land in the reign of Edward III. With regard to real property in an office to be found for the king, it puts him in immediate possession without the trouble of formal entry, provided a subject in a like case would have a right to enter, and the king shall receive all the profits from the time his title accrued. As on the other hand, by articles upon the charters, if the king's excheater or sheriff seizes lands into the king's hands without cause, upon taking them out of the king's hands again, the party shall have the profits restored to him. So somebody's going to get some profits. In order to avoid the possession of the crown acquired by finding such office, the subject may not have his petition of right, which discloses new facts as found, may not only have his position knife, which discloses new facts not found from the office, and his his plea of right, which relies on the facts as found. But also he may, for the most part, traverse or deny the matter of the fact itself, and put in course a trial by common law process of the Court of Chancery. Yet still, in some special cases, he has no remedy left but a mere petition of right. These traverses, as well as petition of right, were greatly enlarged and regulated for the benefit of the subject by statutes before mentioned. And in traverses thus given by statute, which came in place of old petition of right, the party traversing is considered as plaintiff, and must therefore make out his own title as well as impeach that of the crown, and then shall have judgment by something. So this when he becomes the plaintiff, must therefore make out his own title as well as impeach that of the crown. He has to say who he is and say that you're not. Where the crown is unadvisedly granted anything by letters patent which ought not to have been granted, or where the patentee has done an act that amounts to a forfeiture of the grant, the remedy to repeal the patent is by writ, show cause, and chancery. This may be brought either on the part of the king in order to resume the thing granted, or if the grant be injurious to a subject, the king is bound of right to permit him upon his petition. So he has to do the petition, not the plea, but the petition, to use his royal name for repealing the patent. And so also, if upon office untruly found for the king, he grants the land over to another, he who is grieved thereby and traverses the office itself is entitled before issue joined against the patentee in order to avoid the grant. So what's been done in the law or in statute can be undone as soon as the office is found. It differs from an information filed in the court of the king's bench, of which we shall, and here's information, an accusation or complaint made in writing to court of competent jurisdiction on behalf of the crown, filed with the exchequer by the king's attorney. That would be the county prosecutor, the king's attorney general. It's a method of suit for recovering money and other chattels or obtaining satisfaction damage for person wrong committed in the lands or possessions of the crown. So I guess if somebody had a problem with the king, they would take it to the king's attorney, and he would enter it into the system. But the one we're talking about differs from the information filed in the king's bench, for which we shall treat in the next book, in that it is instituted to redress a private wrong for which the property of the crown is affected, that is calculated to punish some public wrong or heinous misdemeanor in the defendant. It is grounded on no writ under seal, but merely an intimation of the king's officer, the attorney general, who gives the court to understand and be informed the matter in question, upon which the party is put to answer, and a trial is had in the suits between subject and subject. Well, you're not a subject, right? So that's why you're not supposed to be in this court. It's between subject and subject. Private man, private man. So you can be private man, which is inferior to man, or you can just be man, which is synonymous with king. The most usual informations are those of intrusion and debt. Intrusion for any trespass committed on the lands of the crown by entering therein without title. Holding over after a lease is determined, taking the profits, cutting the timber, or the like, and debt upon any contract for monies due, securities, statute staple, statute merchant, due the king, or any forfeiture due the crown upon breach of penal statute. This is most commonly used to recover forfeitures occasioned by transgressing those laws which are enacted for establishment and support of revenue. Others, which regard mere matter of police and public conveyance, being usually left to be enforced by common informers, prosecutor. So if the prosecutor brings a case, that's different than an attorney bringing a case, a subject on subject, right? If it's a matter of police or public conveyance, then the prosecutor's involved in the popular informations or actions for which we have formally spoken. A popular action, punishment, an action given by statute to anyone who will sue to the penalty. To sue, to prosecute or commence legal proceedings to the purpose of recovering a right. To sue what? For the penalty. The penalty, a clause in an agreement by which the obligor agrees to pay certain sum of money if he shall fail to fulfill the contract contained in another part of the agreement. So I think this is where the attorney's putting up his bond or surety or whatever it is. He's placing his bet on one side that he's going to be able to get you to acknowledge these statute, staple, statute merchants. And if not, then he's paying the bill and you're getting damages. But after the Attorney General is formed upon breach of penal law, no other information can be received. Well, what's a penal statute? Those that inflict penalty for violation of some other provision. It's a rule of law that such statutes must be construed strictly. They cannot therefore be extended by their spirit or equity to other offenses than those clearly described and provided for. So, what we got here? Recover forfeitures occasioned by transgressing those laws and act to establish support of the revenue. Well, regard mere matters of police, right? So anything that doesn't have to do with the prosecutor coming in the name of the state is a recovery forfeiture, and it's a popular action. In the popular informations or actions from which we have spoken. Action by statute to anyone who will sue for the penalty, to prosecute or commence legal proceedings for the purpose of recovery of right. An obligor agrees to pay a certain sum of money if he shall fail to fill the contract contained in another clause in the same agreement. But after the Attorney General is informed upon a breach of penal law, so if they're claiming a penal law, no other informations can be received. Penal statutes, those which inflict penalty violation of some provision. It's a rule that such statutes may be construed strictly. They cannot therefore be extended by the spirit and equity to other offenses than those clearly described and provided for. So first thing we need to know, one of the things we need to know is, please define the penal statute that's in this package. There is also information in rem when any goods are supposed to become property of the crown, and no man appears to claim them, or to dispute the title of the king. As anciently in the case of treasure trove, wrecks, waifs, estuaries seized by the king's officers for his use, upon such seizure, an information was usually filed with the king's exchequer, and thereupon proclamation was made for the owner, if any, to come and claim the effects. So they say all our property is abandoned, right? And somehow they're sending us a piece of paper that sounds to me, when we get into this next page, that if we took it to them, they would give us the money. And at the same time, they're issued a commission of appraisement to the value of the goods in the officer's hands, after the return of which a second proclamation had, if no claimant appeared, the goods were supposed derelict and condemned to the use of the crown. And when in later times forfeitures of goods themselves, as well as personal penalties of the parties, were inflicted by Act of Parliament for transgression against the laws and customs and excise, the same process was adopted in order to secure such forfeited goods for public use, though the offender himself had escaped the reach of justice. Okay, so now there's a thing called a writ quo warranto. By what warrant is the nature of a writ of right for the king against him who claims to usurp any office, franchise, liberty, to inquire by what authority he supports his claim in order to determine the right. So if somebody's brought something to you, let's narrow this down now. If somebody has brought a case against you, right, you're not going to answer to that case. You're going to do a writ of right for the king. It lies also in cases of non-user or long neglected of franchise or misuser or abuse of it, being a writ commanding the defendant to show by what warrant he exercises such a franchise. having never had any grant of it, or having forfeited by neglect or abuse. Okay, so franchise, word has many significations, conferred by grant from the government and vested in individuals. Show me the franchise I gave you. Corporations and body politics are those most usual franchises known to our law. They have been classified upon incorporeal rudiments, perhaps improperly, as they are no inheritable quality. In England, franchises are very numerous, and they are said to be royal privileges in the hands of the subject. So we gave them a privilege to have the franchise. Show me that I gave it to you. This was originally returnable before the King's Justice at Westminster, which I think they mean going into Chancery, but afterwards only before justices in ear in the circuit, by virtue of the statutes of Quo Warranto. But since those justices have given place to the King's temporary commissioners of assize, the judges on the several circuits, this branch of the statutes has lost its effect, and writs quo warranto, if brought at all, must now be prosecuted and determined before the King's justices at Westminster. So you need to take your writ. See, this is where you're going to get an original writ suit out of Chancery. They're talking about taking this to Chancery, asking for this to be done, and they're going to put a seal on it. A short account of the writ made by the sheriff or ministerial officer of the manner in which he executed the writ. Now, I'm not really big on what returning of writs are and so forth, so these are things I still have to figure out in my head. All I'm saying is, where you used to take this to the circuit court, now it looks like you take it to the chancellor. And I'm not saying he doesn't have a representative at the courthouse, but one of the things we need to find out, where do we sue out a writ of quo warranto? And in case of judgment for the defendant, he shall have allowances of his franchise. But in case of judgment for the king, for that the party is entitled to no such franchise, or disuse abuse, the franchise either seized to the king's hands to be granted out again to whoever he pleases, or it be not such franchise as may subsist in the hands of the crown, there is merely judgment of ouster to turn the party out who usurped it. Judgment by this writ, being the nature of a writ of right, is the final and conclusive event against the crown, which together with the length its process probably occasioned the disuse into which it has now fallen, and introduced a more modern method of prosecution by information filed in the court of the King's Bench by the Attorney General in the nature of a quo warranto, wherein the process is speedier and the judgment not quite so decisive. This is properly a criminal method of prosecution. Criminal methods are done by pleas of the crown, as well as punish the usurper by fine for the usurpation of the franchise, as to oust him or seize it for the crown, but has long been applied to mere process of trying the civil right, seizing the franchise and ousting the wrongful possessor, the fine being nominal only. Okay, so it's got a small fine, but it's going to take the guy out of his franchise. So, in my opinion, attorneys have franchises, right? This is going to remove his franchise when you take, by information filed in the court of the King's Bench by the Attorney General. So, the Attorney General, the prosecutor, is the one who's going to file it. We just send it to him. My opinion. So during the violent proceedings that took place later in the reign of King Charles II, it seems, among other things, expedient new model most of the corporate towns of the kingdom, for which the purpose many of these bodies were persuaded to surrender their charters and information in nature of quo warranto were to be brought against others upon supposed or frequently a real forfeiture of their franchises by neglect or abuse. And the conveyances was that the liberties most of them seized into the hands of the king, who granted them fresh charters with such alterations as were thought expedient, and during their state of anarchy the crown named all their magistrates. So a lot of stuff was going on whenever this King Charles II, There were some tumultuous times. I wonder what happened. I don't know when King Charles II was in reign. The exertion of power, through perhaps in strict right, it was for the most part strictly legal, gave a great and just alarm, the new modeling of all corporations being a very large stride towards establishing arbitrary power, and therefore it was thought necessary at the Revolution to bridle such branch of the prerogative, at least so far as regard to the metropolis, which enacts that the franchise of the City of London shall never be forfeited for any cause whatsoever. This proceeding is, however, now applied to decisions of corporation disputes between party and party, without any intervention of the prerogative by virtue of the statute, which permits the information in this form to be brought with the leave of the court at the relation of any person desiring to prosecute the same, who is then styled a realtor, against any person usurping, intruding into, or unlawfully holding any franchise or office in any city, borough, town, corporate, provide for its speedy determination, and directs that if the defendant be convicted, judgment, ouster, as well as fine, may be given against him, and that the realtor shall pay or receive cost according to the event of the suit. So if you bring a real thing, if you bring this action in as a realtor to the Attorney General to be filed against any person usurping, intruding, or unlawfully holding any franchise or office in a city, borough, town, corporate, you can have them kicked out. And we also got the writ of mandamus. We command is also made by the same statute. A most full and effectual remedy. A most full and effectual remedy. In the first place, for refusal or admission, where a person is entitled to take an office or place in any such corporation, and secondly, for wrongfully removal when the person is legally possessed. These are injuries from which, though redress from the party interested may be had by assize or other means, yet, as the franchise concerns the public and may affect the administration of justice, the prerogative writ is issued from the court of the King's Bench, commanding, upon good cause shown to the court, the party complaining to be admitted or restored to his office. The statute requires that a return be immediately made to the first writ of mandamus, which return may be pleaded or traversed by the prosecutor, and his antagonist may reply, take issue, and demur. Same proceedings may be had as if the action on the case had been brought for making a false return, and after judgment obtained from the prosecutor, he shall have peremptory writ of mandamus to compel his admission or restitution, which later, in the case of action, is effected by writ of restitution. So that now the writ of mandamus in the cases within the statute is in the nature of an action of a writ of error may be had thereon. It is in the nature of an action, and a writ of error may be had thereon. The writ of mandamus may also be issued in pursuance to the statute in case where at regular time no election shall be made of mayor and other chief officer of any city, borough, town, corporate, and be made it shall afterwards be void, to require the electors to proceed to election, and proper officers to be held for admitting, swearing to the magistrate so respectively chosen. We have now gone through the whole circuit of civil injuries and redress which the laws of English have anxiously provided for each, in which the student cannot but observe that the main difficulty which attends their discussion arises from the great variety which is apt of our first acquaintance to breed a confusion of ideas and kinds of distractions in memory. A difficulty not a little, I can tell you about that, yeah. A difficulty not little increased by the very immethodical arrangement too justly complained of in our ancient writers. Alright, so they're complaining about the way things are written. Terms of art will unavoidably be in science. You got to learn the terms. This difficulty, therefore, however great it may appear at first, will shrink to nothing upon nearer approach, and be rather advantageous than of disservice by imprinting a clear and distinct notion of the nature of several remedies. As such, as it is, and arises principally from the excellence of our English laws, which adapt the redress exactly to the circumstance of the injury, and do not furnish one and the same action for different wrongs, which are impossible to be brought within one and the same description, whereby every man knows what satisfaction he is entitled to expect from the courts of justice, and as little as possible is left to the breast